Good morning, good afternoon, good evening, wherever you are in the world. This is Nelson Ogunshakin, the CEO of FIDIC. Welcome to the FIDIC COVID-19 Webinar Series. This is the second of the many series we are giving. We deliver one on Tuesday to look at what are the geographical challenges across different parts of the world. And I'm pleased today that we've got excellent panelists who will help us to navigate the issue about COVID, impact on contract labor activities, and issue to do with force majeure. Before I kick in, we do have 1 hour, 30 minutes to deliberate on the subject at time. The intention is for me to give 5 minutes welcome. I will then invite each panelist to speak between 5 and 10 minutes on the subject chosen. Thereafter, I'll probably give 10 minutes in the session where I'll be throwing questions at the panelists. Hopefully, they'll be in a position to assist us. And after that, I will take questions from the floor and prepare to put it across to the panelists. Now, before I give it a kickstart, it will be a case that I just need to set the scene. FIDIC represents over 102 countries around the world, and over the last 1 year, there's a number of challenges that we've been facing, but we are, like any other organization, facing the issue to do with COVID. We have two options. We either respond positively or we be ignorant of it. We choose to take a proactive approach. Our board has taken a number of decisions over the last 1 month to address the issue. One is a cancellation of our annual conference because this is absolutely important. But secondly, is to put in a guide out to all our members and stakeholders in the industry, and we've done that very well. We are open to suggestions for any further ideas on how we can help our industry. But actually, our philosophy is very much to create an ambient and a sustainable industry. Having said that, we've identified 20 topics to cover over the next 10 weeks, and we aim to deliver 2 per week. We started off on Tuesday with the very first one to look at the geographical sector of the world and see what is going on the issues, and particularly to look at how our industry and our member association are looking at it. We had speakers from Australia, from India. We also had speakers from Italy and speakers from actually the Far East. Overall, including Canada, I think the feedback has been very good. Today, we're privileged. We have maximum capacity of 1,000 delegates to register, and we've got 1,000 delegates to register. So I hope over the time we'll be able to retain more than 75% of that. The topic is very interesting. Can I put a caveat? Whilst we intended to cover the variety and the various issues that covers this subject, we do not intend to give legal advice. You are advised to contact your legal counsel on any matter related to your contract that you're involved with. But having said that, FIDIC promotes best practice, and we are talking to you this afternoon or this morning or this evening, wherever you are in the world, on best practice. On this note, I'm going to invite our president, Bill Howard, to say a few words. Bill, the floor is yours.
Well, thank you very much, Nelson, and I will try to be very brief. The first thing I'd like to do is to welcome everyone and thank everyone for participating in this very important webinar. Over a short period of time and remotely, our CEO, Nelson, and the Secretariat have put in a lot of effort to put these webinars together. This is the second one that we're having, and arguably one of the most important, because we're talking about some pretty heavy issues that a lot of us will be facing related to our contracts. So thank you very much to Nelson, the Secretariat, and particularly to our speakers today, who will be presenting their views on the various issues. The final thing I want to say is something that most of you probably already know, is FIDIC historically has put a lot of effort into developing recommended conditions of contract that are fair and equitable to all parties in the contract. And I would submit that it's times like these where a high quality, fair contract is an asset to everyone involved in getting us through these very trying times. So with that, I'm looking forward to hearing from our speakers, and I'll turn it back now to Nelson, and thank you again for participating. Nelson?
Thank you very much, Bill. Thanks for that welcoming speech. Really, at this point, I'm going to invite Aisha Nadar, our board member, who has number one responsibility for overseeing what we do in the contract framework. And of course, her reputation is out there, and I don't need to introduce her. Aisha, the floor is yours. Give us a few words. Thank you.
Thank you very much, Nelson, and thank you very much, Bill, both for your leadership in this very trying time. And the world is partnering together to get us through COVID-19 and the risks that we're facing and the experiences that we're all facing. And FIDIC is certainly, you're helping FIDIC to step up to the plate and do its part in participating and partnering in getting everybody through this safely to the other side as best we can. Now, Bill mentioned our contracts, and we're focused on this seminar about the contracts. I'll just briefly speak for a couple of minutes on the history of FIDIC contracts and our relationship with contracts and capturing and disseminating best practices and having a tool that allocates risk between the parties in an fair and an effective and balanced fashion. FIDIC published its first standard contract in 1957, and since then has been focused on market needs and developing and delivering a broader spectrum of contracts. We have currently a family of FIDIC contracts, the most notable of which is the Rainbow Suite for major works, and the principles behind those contracts is a fair and effective allocation of risk between the parties. And FIDIC has really four maxims of allocation of risk, and that is the risk is allocated to the party that can best control that risk or the consequences of that risk if it eventuates. Which party is in the best position to foresee the risk and control it from happening? Which party can bear the risk? And which party will most benefit from the risk in case it eventuates? The risk of COVID-19 is obviously an exceptional risk. The FIDIC contracts have mechanisms, and I will turn it over to my colleague, the chair of the contracts committee, Vincent Leloup, to talk about how FIDIC addresses risk and how FIDIC addresses exceptional risk in a mechanism of force majeure in the 99 suite. So with that, I welcome you today. I look forward to partnering with all of you on the call. I see we have quite a number of people on the call, and I thank you again, Nelson, for taking this initiative. I turn it back to you, Nelson.
Thank you very much, Aisha. That is very good for us to move forward. We got four excellent speakers, to give it a kickstart. I'm going to do a very quick introduction of each one of them, and then I'll start with Vincent. Vincent is the FIDIC Contract Committee, chair, oversee the whole of the development of FIDIC contract, and he's been involved with FIDIC for over 15, 20 years, actively involved in the market. Vincent will be followed by Clare Marshall. Clare is the Group Legal Director for Arup, and I'm privileged to say that I've known Clare for possibly over 20 years. Arup is a name that is well known in the industry with global footprint all over the world, and hopefully they've had different sort of jurisdiction to operate, be it on FIDIC or no FIDIC contract. So that would give us a perspective from consulting practice, perspective. That will be followed by Angus, who is being a partner at Hogan Lovells, and they've been partnering with us in our first issue of guidance note we put out. And thank you very much, Angus, once again. And he will look at it from a legal point of view. I mean, I know Angus will tell us that whilst I do not wish to give you legal advice, you are welcome to come and talk to them. But going forward, after Angus, I would bring in Charles Kim. Charles is the General Counsel and Corporate Secretary for American Council of Engineering Companies, which is a member, perhaps the biggest member of FIDIC, member association around the world. And Charles will give us a perspective from United States and also from their own perspective as a member association overseeing the needs of the American consulting firm. Without further ado, I'm going to hand over to Vincent, who will give us a kickstart. Vincent, the floor is yours.
Yeah, thank you very much, Nelson, and good morning or good afternoon to everyone. So for my opening part, I would just focus for this time on the way we could handle this current situation under our forms of contract, but I would focus on our forms of works contract. We have another webinar next week, which will be dedicated to consultancy services agreement, and typically this will be the time when we can talk about the white book, for example. So I would focus on the works contract that we have, and mostly indeed the 99 suite, red, yellow and silver books, but also the 2017 update of that suite. I would also just highlight a caveat first, which is what I'm going to say is about the contract terms as they are. As you all know, of course, the contract terms are to be interpreted in accordance with the relevant applicable law. So my colleagues from the panelists will give us an insight as to the way this situation can be handled under certain jurisdictions. One I am very familiar with is France, and of course, when we are talking about force majeure in a 99 suite of contracts, there is possibly a clash with the way force majeure is defined under French law, for instance, in Article 18, sorry, of the French Civil Code. So these kind of things are, of course, to be looked at. And some of you might be aware that the reason why we talked about force majeure in the 99 suite and the reason why we talk now in the 2017 suite about exceptional event is that we wanted to stay away from any possible interpretation clash in between what the contract says on one hand and what your applicable law may say on the other hand. And finally, a last preamble remark is that you know that some governments across the world are now issuing orders or recommendations as to the way to apply contract provisions. So what we're going to highlight now in terms of what is the contract saying about this situation, we should not forget that the strict application of those contract terms might be well affected by government decisions. I'm thinking about, for example, the UK Cabinet Office, who issued on the 6th of April some recommendations about standard terms to be applied on construction contract for public works. We have similar provisions in France, where the government passed an emergency law 2 weeks ago, and where they have the power, for example, to bring some amendments to the application of contract terms with the overall objective of preserving cash flow being the lifeblood of businesses, and in order to avoid to have a series of companies going into insolvency. So there is a kind of that if I focus you can, of course, immediately think about the force majeure situation. That's probably the one thing people think of when we are dealing with this current situation. Bear in mind, however, that epidemic or pandemic are not expressly covered in the clause 19 of our 99 suite, or are not expressly covered either under clause 18 of the 2017 suite. That being said, that is not an impediment in itself, because the list of events which have been given in clause 19.1 in 99 or 18.1 in 2017, this is just an indicative list. It's not the force majeure events or exceptional events are not limited to the examples we have given there. And as long as one does pass the four-step test, which is set out in clause 19.1 in 99 or 18.1 in 2017, then you could consider that you are dealing with a force majeure event. So out of the blue, I would say that people tend to think that yes, that seems to be clearly and squarely a force majeure event or exceptional event. Bear in mind, however, that there might be a difficulty with one of the four conditions for that, which is that when an event occurs, such party could not reasonably have avoided or overcome that event, we are seeing currently that after a stop in some countries of construction activities following government decisions, and there is a resumption, a progressive one, as long as people implement the right health and safety precautions on site. So there might be a challenge there, so that you might be aware of that. The second point is that the entitlements you get outflowing from a force majeure event or exceptional event in 2017 suites are mostly about time, extension of time for completion, which can be granted to a contractor, as long as, of course, he can demonstrate that this situation has prevented him from performing any of his obligations, which is, of course, very much likely to be the case in our present situation. So the time side is one thing, but there is no explicit and clear entitlement for a money relief due to this situation. So typically prolongation cost, if you are stopped for, let's say, 2 weeks for going on site, and while you are figuring out whether you can resume your activities with the right health and safety measures, there might be a difficulty to win a prolongation cost claim, given the fact that our contracts provide for a money relief when we are talking about man-made force majeure events, while when we are talking about natural events, there is only an extension of time entitlement. So of course, if you run the argument conspiracy theories we see all over the place that this would be man-made of some form, you may win on that approach, but of course it's very much unlikely, and I would say the odds are more that we would be seeing this as a natural event, and so no express cost relief provided for that. I think what, on the other hand, people can look at is provisions like the clause 13.7 in our 99 edition or 13.6 in 2017 edition about the effects of government decisions right now. Those clauses are about change in law, and they provide for cost and time relief whenever there is a change in law which will affect the performance of obligations by the contractor. The definition we have of law is pretty wide. It's not only legislation, it's also regulation, it's order, decrees, either from a state entity, but also down to the very local level. So you may have a government order which might be amplified at municipal level, for instance. Your government may say, I do not prevent you from carrying out your construction activities, but your municipality may say the opposite or may put more restrictions to your job site. So that's something which would be captured by the definition of law, and that gives the contractor an entitlement for cost and time. Bear also in mind that this, even though you don't have any ban, for instance, to deliver your construction activities on site, the law may now, or the regulations may now impose new requirements, new health and safety requirements. And those health and safety requirements might well be treated as variations under the contract. Actually, in our 2017 suite, when there is a change in law which has an effect on the execution of the works, on the way the works are implemented, if there is an adjustment to the execution of the works which is required, then the variation clause kicks in. And the variation clause itself provides for time and cost relief, but also on top of cost, you are considering profits, because if you are working under the Red Book, for instance, then as a first reference, you would look at the rates which you have under the contract in order to value the variation. So variation should be kept in mind. And I would say more globally also the obligation anyhow for the contractor to comply with the health and safety regulations and the laws and what is set out under the contract. That's something you find under subclauses like 4.1, 4.8, or also clause 6.7, which expressly covers the question of the epidemic by stating that the contractor shall ensure that suitable arrangements are made for all necessary welfare and hygiene requirements and for the prevention of epidemics. I would say finally, if you have difficulties with your force majeure case or exceptional event case, if you have difficulties with using clause 13.7 or 13.6 regarding changes in laws, and let's say if you have had no impact, no government decision impacting your job site, Don't forget also specific provisions that we have, like under clause 8.4, paragraph D, which can provide for a time relief in case you get unforeseeable shortages in the supply of goods or personnel, and which are caused by epidemic or governmental action. So that's the case, for instance, currently in some countries where a country does not have a very vivid COVID situation, but is affected by other countries nearby. So there may well be an impact on the supply chain suffered by the contractor. Also, his own personnel might be reluctant to go on site for safety reasons. So that's something to bear in mind in that respect. And finally, if it might also be that the employer is taking a proactive stance and say, well, I want to stop all activities on site because of the risk flowing from that situation, you may look at subclause 2.1 for stopping access to the site, 8.8 for suspending the works, which is 8.9 in the 2017 edition. Of course, the employer can well argue that this is flowing from a force majeure case, and which makes that he is entitled to suspend performing his obligation to give access to the site. But that's basically a rough overview of the various angles, and you could consider looking at the situation. And just bear in mind that we will publish in the next couple of days a guidance memorandum from the contract committee, and that will be published on FIDIC website to help you looking at the various options under your contract to deal with the situation. So that's all for me now. Thank you.
Thank you very much, Vincent. Thank you for that, what I call speedy overview of the FIDIC contract, particularly to look at the issue about force majeure in its widest context. And as Vincent said, there will be a follow-up on the specific one to do with consulting engineers, and we'll pick that up on that. A number of points being raised by Vincent. I'm making a note of that, and I'll come back to that later on. Without spending too much time, I'm going to invite Clare Marshall to give us her perspective from consulting firm. Clare, the floor is yours.
Thanks very much, Nelson, and thanks very much for inviting me along today. I wanted to take the opportunity, actually, before I start, just to remind us all of why we're here and the significant human cost and the tragic situation that we're in. And, you know, I'm sure we all share sympathies with those affected and want to pay tribute, really, to all of those people on the front line dealing with this health crisis. I think that's very important to note. What I wanted to do really was zoom out and give a bit of a bird's eye view from a consultancy perspective, a global consultant with roughly 17,000 live projects at the time of this situation beginning to emerge, and approximately 17,000 people working now remotely. The bulk of our staff are now working remotely. So for our firm, obviously this has created significant challenges, but also lots of opportunities are arising out of the situation. As General Counsel at Arup, obviously that creates a number of issues to grapple with, not only in terms of contracts, and which I'll come back to shortly, but many issues, a whole range of situations to consider and plan for and support. A key focus for us and a key objective really has been putting at the centre of this, obviously, the health, safety and well-being of all of our people, our staff, and also those we collaborate with. That's very much central to the decisions that we're making as a business, and including at project level, obviously very important. And then secondly, our clients and our projects are obviously very important to us, and looking at the ways in which we can continue to support our clients and those projects, and keep the industry afloat as much as possible by looking at opportunities to restructure projects, and when the time comes to help reboot projects that have had to be suspended or otherwise put on hold. So those are all important things that I wanted to emphasize, that I think we as an industry, whatever our roles are in the industry, really to not get too bogged down in the contract side of things. It's important, and I will come back to that, but to step out a little and be creative, be collaborative and, you know, find solutions so that we can all work towards keeping our industry and the wider built environment that we all work in ready to restart once this situation is behind us. I think that's very important. So in addition to health and safety and well-being being an immediate issue in terms of remote working and the considerations there around our staff, obviously at a project level, very important considerations, as we're just alluded to, around particularly as a consultant on construction projects, supporting sites and undertaking our roles as either contract administrator or supervising projects, etc., monitoring construction, and how we could fulfill those obligations, continue to on projects that are still proceeding, and in some areas how we can do that remotely. And again, this is very interesting and leads me into the next point around technology, and I think this webinar is, you know, a key demonstration of what's actually achievable with the technology, the amazing technology that we now have. But how that is extending into not only how we deliver our professional services, which as you can imagine, we can do a lot of our services remotely, as long as we've got the BIM model capability and all sorts of things on our laptops at home. All of these things can continue, but it's also in that context of site, and I think this is where we see innovation in the industry, how we can achieve things using technology. So we had a really amazing example this morning on one of our calls about using GoPro on a construction site. You know, the contractor, who was all properly kitted out with PPE, had his camera, and our engineers were monitoring, watching, asking him to go and look at certain things, and then they were able to take those issues forward on that project. So really good example there of some practical things that technology can help with. We'll be looking obviously at all sorts of other things there to help deliver our services. It's also obviously been critical to enabling technology, that is, to enabling us to stay connected as a business and with our clients and all of our collaborators and stakeholders on our projects. Absolutely critical to that. And I'm pleased to say that actually many of our projects continue to run. They're still running, we're still winning projects, and that's all very positive. But obviously we appreciate the ramifications of the situation and where this could be heading from an economic perspective. So in terms of relationships, I just wanted to touch on the importance of this. And you know, as I say, really important to be collaborative across our projects with all of the stakeholders and different parties involved. We are in an unprecedented situation. You know, we've never faced a situation like this at a global level. We're all in this together. Let's work through it and find solutions together as best we can in each of the very individual situations that we'll face on each of the projects that we have around the world. And really engage with all of the different participants on the project. So really, I think that's an important area, again, that FIDIC has been promoting for a very long time, and I know Nelson has since I first met him, about the importance of project collaboration. And I think at this time it's absolutely critical. So coming on to the contract, you know, at times of crisis, you hear that you know, to avoid chaos, you need some rules, and there are Arup is an organisation that we like to have rules. It's very innovative, very creative, but there are circumstances where some rules, actually some guidance, is very helpful. And actually, I think this is where, you know, the importance of a contract comes in. So on each of the projects that we have as a business, but also more broadly across the industry, really knowing your contract and sticking to the workings of the contract is going to be really important. And that's not only from the, not from a viewpoint of protection and getting ready for claims later, but actually it's a two-way thing, or it could be a multi-party thing where it's about engagement, it's about relationships, it's about managing expectations and bringing things to the different parties' attentions at the right time so that steps can be taken to minimize the impact of different issues. And I think the other thing to emphasize is the complexity that we're dealing with here in relation to projects and all of the web of contracts that will be impacted. So I think that, again, collaborating to look at the path through these challenges is really important. So I won't repeat the long list of, there's a whole inventory of issues that people need to be considering under their contracts, which have already been touched on actually by Vincent, and I'm sure other speakers will come back to them. But obviously, following the contract, adhering to the contract requirements, communication, absolutely key, notice requirements, all of those things are very, very important. So at a global level across the business, my team are very busy supporting the business look at their individual contracts that are affected and providing advice on the steps that need to be taken. So Nelson, shall I leave it at that?
Thank you very much, Claire. That's a very good insight to looking at how I expect nothing more than that from a global consulting practice. Thank you very much, Claire. And we'll come back to you later. I mean, I think, it's fair to say you're a good starting point. Remember those people who've been victim and people who are at the front line, I think is quite fundamental. I think the point you raised about our business, about people, we need to put people first, and relationship is quite essential. So I'm going to invite Angus now to take the floor, and I'll come back to you later on, Claire. Thank you very much. Angus, the floor is yours for 5 to 10 minutes. Give you your perspective. Thank you.
Thank you very much, Nelson. So I'll keep my comments fairly brief for two reasons. One is I want to allow plenty of time for panel discussion and Q&A, but I think more importantly, because I agree wholeheartedly with the comments already made by Vincent and by Claire. I think it's marvelous that we could hear Vincent's comments straight from the source, if I could put it that way, and the contracts drafting committee, and of course all the observations that Claire and an organization like Arup have to offer absolutely hold good. It may seem surprising that I, as a second lawyer on the panel, the third lawyer so far, should start again by looking at the importance of contract relationships, but it absolutely is where I want to start. Yes, these contracts have their machinery, and entitlements have to be proven, and well, rights have to be reserved and entitlements have to be proven. We can come on to that a bit later, but I think absolutely now is the time. With these unprecedented challenges, it may require an unprecedented level and style of engagement with your counterparties. That, of course, and conscious that FIDIC users and members will be facing in multiple directions, up the supply chain to their customers, or clients, down the supply chain, of course, to vendors, subcontractors, and so on, contract administrators, engineers, employers' representatives, clearly often combining the roles of contract administrator, but also seeking to make a fair determination of contractor claims. But in all this, I think the focus of this section, this session on the wider picture is absolutely paramount. FIDIC offers an excellent framework for dealing with unexpected events, but I don't think any contract on earth could really have contemplated the headwinds that really the whole industry is now seeing. So I think if you have FIDIC, you have a map which is well proven, which has evolved over time, which I think is important. And I think there is obviously scope there if you read your contract and you follow the FIDIC scheme and you adhere to notice procedures and the other obligations on you as the party notifying the claim. There is a framework there, but the note of realism always is that the purely contractual adversarial route, and I say that myself as a disputes lawyer, may not necessarily produce the best outcome for the project. And when I say best outcome, perhaps I need to manage expectations. There may be no good choices, but the least worst outcome may require the parties to look outside rather the sort of very strict I win, you lose risk allocation on a particular point. That may become the default, and you should certainly as a party prepare your position for eventual dispute. But I think this is a case where different streams of communication may need to exist in parallel. One, of course, will be the official communications for the record, but I think there also needs to be a very candid, if necessary, without prejudice channel of communication, where the parties can speak much more openly than they might be used to doing. I think that's important about what is really behind them and what is weighing on their mind, because I think without that level of exchange, it's difficult for parties to really understand fully the push-pull and what the optimal or what the best available solution might look like. So absolutely, as Claire said, the relationship is important, and also you have to think about leverage. I don't mean leverage in a sort of purely mercenary way about holding people to ransom, but I mean leverage in the more positive sense that if parties collaborate now, they might be able to exploit windows of opportunity that will otherwise be lost if they simply hunker down, reserve rights, and the unsatisfactory status quo, if you like, rumbles on. So think, for example, of a particular weather window, which, if not fully exploited and utilized this summer, once that weather window is lost, think about what that might then do to push off the project schedule into next year. Now, if you're the party receiving these notices, of course, you will be aware that you can challenge notices both from the point of view of the trigger event, which Vincent helpfully explained. Causation is important. Clearly, parties rightly and sensitive to the enforceable time bars on claims in a standard FIDIC contract, well-advised parties will have prudently given early warning notices and initial notices of claims, and that is well and good. And the FIDIC form sensibly does not expect that that initial notice is going to be able to present a comprehensive picture. This event is so large, frankly, that query whether the fully detailed claim itself, how far that can get a grip on things, but it's important to operate that. But really where I'm heading with all that, of course, is that while initial notices are all well and good, I think we're entering an interesting phase now, of course, where parties really need to turn their minds to causation. And by that, I mean that if you are the party that is claiming relief, okay, you have reserved your rights to claim, you are within time, but you are now going to have to particularize that. So as well as using relationships and understand and follow your contracts, I think my third point is going to be records, records, records. If you are a party seeking relief, whether on the basis of force majeure or change in law or some other provision in your contract, you will absolutely be required sooner or later to establish your entitlement and the causal link. And that will involve significant extra work at a time that you may not have additional or specialist resource dedicated to it, to very carefully and continually update your records of the impact. And that is an impact that has to be disaggregated from other things that may have pushed up cost or caused delay. So while certain aspects of this crisis are frightening and unprecedented, I think a positive message I would give to everyone on this call is that we as an industry and people who work under FIDIC forms in particular are well placed as they are already in the business of analyzing time and cost impacts. So I think there's never been a more important time to be disciplined about that. And there has never been a more important time to record what is happening contemporaneously. Because if the worst comes to the worst, this problem and these dark days are going to be in front of an arbitral tribunal one day in 18 months, 24 months, 36 months and beyond. I can tell you that memories fade and people will struggle to remember quite what an invidious position project players were in at this time. That what the parties were saying at the time in their written correspondence will be taken as most authoritative, even with the best witnesses of fact and the best experts. Your case, your strongest case, is going to have to be built from the ground up using the contemporaneous records. But as I say, think about parallel channels. At the same time as investing in that documentation and claims preparation effort, there will need to be an openness to understanding whether it does no one any good to take the purely contractual route, for example, because even if, let's say, the employer was correct and the contractor was fully exposed up to its delay LD cap, for example, those delay LDs may go nowhere near making the project whole. So I think a couple of different streams have to go on in parallel, although at important points they may be complementary. Those are my initial observations, Nelson. Thank you.
Thank you very much, Angus. I think you pick up three key messages, which from my point of view, I think absolutely paramount. Understanding the contracts and knowing how to work the contract. The notice is very critical, and do look at alternative dispute or maybe engage, as Claire said, in conversation with various parties. And you finish up with the issue about record, because memories tend to fade, and we need to come back to that. And that makes it a very good segue opportunity for Charles to come in. Charles, the floor is yours. I just want to give us, 5 to 10 minutes, and that will open us with a real question and answer session. Charles?
Thank you very much, Nelson, and good morning, everyone. I hope you are all staying safe during this present world health emergency. I appreciate the opportunity to join you this morning to share some thoughts from a US perspective on force majeure provisions in a COVID-19 context. In the interest of time, I will try to just touch on each of the issues that the FIDIC office shared with me for this discussion. First, on whether COVID-19 is a force majeure event. Let me start by saying a few words on the place of force majeure protections in US standard contracts, with which I am most familiar. Most such contracts used by design professionals, such as those produced by EJCDC and the AIA, include force majeure concepts in the delay clause. They may not have provisions specifically titled force majeure, but the language and the protections are present upon a study of the documents. EJCDC added Epidemics in its standard construction contract some 10 years ago. The US federal acquisition regulations and consensus docs also expressly mention epidemics, while COVID-19 may well be covered under broad catch-all language of the AIA's delay and extensions of time provisions. As was noted earlier, the 1999 FIDIC standard contracts included force majeure language, while the 2017 editions replaced the term force majeure with exceptional event. Given the presence of force majeure or equivalent language in a contract, it will still remain ultimately for a trier of fact to determine if a specific force majeure provision encompasses COVID-19, and if so, the degree to which COVID-19 bears on the relief sought. In other words, as with most situations, it comes down to the specific contract language and the facts. It should also be noted that US standard contracts typically provide an extension of time for delays, but not additional compensation, although that may also be available under certain legal theories. It would be good to consult with one's legal counsel for specific guidance. On government regulations introducing restrictions which present challenges for the project and the stakeholders. In the United States, the overarching government action in this regard is the mosaic of stay-at-home or shelter-in-place executive orders issued at the state or local level. At this time, 316 million people in at least 42 states, 3 counties, 9 cities, the District of Columbia, where I work, and Puerto Rico are reportedly being urged to stay home. This represents over 95% of the US population. This could trigger not only contractual force majeure clauses, but also common law doctrines like commercial impracticability that is recognized in a number of states, the US Uniform Commercial Code, and the Restatement Second of Contracts. There have also been additional laws, orders, and regulations that have a bearing on contract performance. On the question of shortages in supply, impact on labor, disrupted activities on site, and health and safety requirements, I sounded out a number of engineering and legal practitioners in recent weeks and days, as well as analysts and insurance representatives. And the picture presently in the United States seems to be mixed. Some firms have reported no present disruption in their operations, while many more have seen dramatic disruptions as a result, as you can imagine, of factors such as interrupted cash flows, work site shutdowns, the need to maintain social distancing, and other considerations. On the continued effect of the pandemic on projects, the effect will largely depend on the pattern it takes as it intensifies and then recedes. Projections on the pandemic's path have encompassed most shapes known to geometry, but one particularly disquieting projection indicates a sawtooth pattern with a series of peaks and valleys as the disease recedes and then resurges because medical protocols may not be held in place long enough, leading to more outbreaks. Needless to say, it will be difficult for stable business plans to emerge in such an environment. On proper communication and notices, Angus has very eloquently and properly focused on the need for providing proper notice in a collaborative context. I would just want to follow on his remarks by emphasizing that the invoking of a force majeure provision requires a strict adherence to the contractual requirements. Any notice requirements should be complied with, but there is an element of timing involved. It would be good to consult with legal counsel to determine if and when to invoke a force majeure clause so as to maximize the potential for relief. On change and collaboration of the parties, As with any difficult situation that necessitates a change in the path that a project takes, it is necessary to preserve, if possible, a good faith collaboration between the parties, as my fellow speakers have noted well. This is more true than ever in this time of pestilence. While contractual protection should be understood and utilized to the maximum beneficial extent, it is important to be mindful as well that a successful project outcome will depend to a significant extent on the degree to which all the parties understand that we are, as Claire noted earlier, all in this together. Merci, mesdames et messieurs. Nelson?
Thank you very much, Charles. Very good point to wrap up. Really, I think you've covered the 5 or 6 points that we raised. I mean, obviously, there's a lot of questions coming through from the floor, and I'm going to try and sort of summarize as best as I can. Bear in mind that I'm not legally qualified, but I have my learning people on the other side. I think, Charles, your approach to look at the point whether COVID-19 is perceived as force majeure, no force majeure, is quite interesting on the take on we have where in United States, government regulation and issues you picked up. You also pick up issue about the shortage, and you said you have a mixed picture, whether is, some is real and some are very dramatic. But the other point which you raised, which I thought was important, you echo what Angus said is about communication. And you also pick up the point that, was said by Clare, relationship is about people and building on that. So that is actually a good point to start. I am going to invite, question from the floor in about 5 minutes, but just to give it a kickstart. And Aisha, you're welcome to throw in a question if you wish to, but I have a few questions that I want to put across to you here. And I think if I start off with Charles, I think because you're the one that just recently wrapped up, the issues about government intervention, because you talked about everybody working from home, over 95% of the population are locked down. So the question I have is, if the government of that particular country, i.e. US, has not introduced emergency measure, but the project are still suspended, is it relevant for qualifying COVID-19 pandemic as a force measure if the government has not, put the idea of work from home or don't go out? Then do you have a situation where you could still interpret it as force measure? That's a question to you.
Thank you, Nelson. Yes, this is a question which has come up in a number of different conversations and contexts with our ACEC member firms. And what we are seeing is that the answer is extremely circumstance specific. For all intents and purposes, even though the United States is not operating under a national stay-at-home or shelter-in-place order, the practical reality is that if you walk outside your front door, whoever you are, you better have a very good reason. You should be in an essential service as expressly defined in the applicable executive order. And in some cases, you even need, it would be good essentially to carry papers, to basically carry certification that you are a professional in an essential area of service and that you are on your way to or from providing those services. This is something which, as an American and as one steeped in America's culture of freedom, is completely alien to our experience, completely unfamiliar, but that is the reality. I guess when you're faced with a once in 100-year event, certain surprises are in store. But yes, to return to your question, I think one would argue that even in the absence of specific government orders from certain quarters, if your jurisdiction is unequivocally bound or covered under an order issued by a mayor, a governor, a county executive, that in itself is certainly evidence that you are operating in a force majeure context.
I put the same question to Clare. Of course, I mean, I know you have a global remit, but then if you take the case of UK, where there is a clear government directive, and I do believe there's a particular government incentive or scheme, you know, I think I heard the word PPM 0220. Looking through that, you know, what is the interpretation from your point of view as a practitioner? Because you do mention earlier on in your previous conversation that quite a lot of your staff are still working virtually at, you know, very, very high percentage, and a lot of projects are still going. And how do you perceive that sort of government intervention, and how have you treated that within the UK or perhaps in other countries as well? Claire.
Sorry, I was just checking my mute had come off. Yes, it's obviously quite complex, and it is very different in different countries and under different contracts, because sometimes you will have an express provision that gives an entitlement and sometimes not, quite commonly not actually in professional services agreements. So that's a challenge. But yes, we're obviously looking at it on a project by project basis, and in discussion with clients and other project participants to determine the best way forward has been our approach in many different countries around the world. And some projects have in fact been put on pause, even in the UK. Others have not and are continuing, and then we're looking at appropriate measures to put in place to assess. You know, a lot of it's about risk assessing as well for our staff, what's involved, and whether we can perform our services, ensuring their health and safety and well-being is obviously paramount importance. So that's a key consideration. If we're working through that risk assessment, then we will continue to perform the services. But as I said earlier, because of the nature of the services we perform, as opposed to building things where consultants, we're designing, we're advising, we can do a lot of our work remotely. So we're in a fortunate position in that respect. And where we do go to site, as I say, we're using technology where we can to assist with that. So we haven't been in a situation yet where we've needed to start really digging into the force majeure option, and hopefully we'll continue to be in that position. But it's complex, and it does depend on the contract and the law that applies, because some laws will introduce that concept even if you don't have it in the contract.
Thank you very much, Claire. The question I was going to put across to, I think you'll probably do Vincent now, and probably Vincent and Angus now. There is the issue of the magic 84 days. I think you probably know where I'm coming from, which is, you know, if the work is not substantially completed and you have this issue continue over a period of 84 days under the FIDIC, you know, rule, what is your interpretation of that? You know, Vincent? Can you unmute?
Yes. Yeah, I think it's all good now. Yeah. Yes, of course, that's a specific remedy which is found in our force majeure or exceptional event clauses in the 99 suite or 2017 suite. But that's somehow, I think, in our current situation, as it was rightly highlighted by Claire, Charles, or Angus, I think it would be probably going the very hardline approach, because this provision that you refer to, Nelson, allows a party to terminate the contract on the account of a force majeure event whose effect have continued for more than 84 days. I think we are probably still very much away from looking at this particular situation, and I don't think this is definitely the approach taken by communities and governments all across the globe currently, where the onus is more put on promoting collaboration in between the parties, promoting cash flow preservation, and promoting consensual approaches rather than dispute-prone attitudes or adversarial attitudes. So yes, strictly speaking, the terms of the contract, of our contract, provide for such a remedy, but I think we should not be looking into that direction right now, if I may.
No, thank you for raising that. The reason why I raised that question is, as you know, it's been said by all speakers, nobody knows exactly how long this thing is going to go on for. And when you listen to different governments, the sort of lockdown period changes from one place to the other, even across Europe. There's a possibility of an extension, and that's why I raised that issue. The same, perhaps same question, slightly, you know, different to Angus. I'm looking at it from the point of view, I think you raised quite a number of key points about, yes, the FIDIC contract is a fantastic, excellent document, and it allows you to work the way you should do. You have to abide for it, and it gives you that leverage that if you abide by that, things should work okay. But you did talk about the issue about alternative approach, which is getting close to the client and getting everybody on side, which again, I think Clare talked about collaborative issue. Is there, under the FIDIC contract, an opportunity for, you know, wherever the parties are in the whole midst of that, to renegotiate the contract under this particular situation?
Thanks, Nelson. Well, I should avoid giving the classic lawyer's opening of it depends. But it will certainly depend on a number of factors. Of course, whether the parties have made their own embellishments to the contract itself. But I think to your point about a platform for renegotiation, that is probably more likely to come from, if you like, the factual situation of the project and the balance of power, if I can put it in that slightly unhelpful adversarial way, as to what stage of completion are the works at. I think an enormously important point at this, of course, is the people sitting at the top of the tree, lenders, equity investors. That's probably another very interesting webinar in its own right. But I think crucial will be really how the people who are funding the projects, what do they see as the best way to mitigate their losses potentially and rescue the project? And furthermore, and I think linked to that is a critical question about whether or not what is being built, how urgently is that now needed? Because we have works at various stages of completion, which will, if you like, on any view, arrive to the market in their completed state at or around the time that we are seeing huge economic turmoil. So whether we think that the rebound is going to be V-shaped or some other weird and wonderful shape, that is also, I think, going to be one of the many factors that you have to put into the equation as to the potential for a deal. Is this something which still needs to come to market? For example, because an arrangement with an off-taker mustn't be allowed to reopen, or a particular government incentive for renewable energy. The entire model of the project is based on that. What are the push and pull factors there? Or alternatively, is this a case where it makes more sense for the incomplete works to be put into a sort of deep state of mothballing and preservation until better times? But of course, that itself is not something that would be contemplated under the contract. And again, an interesting question would be, how do you deal with the ramifications of that with respect to things like defect liability periods, when no one ever envisaged that installed equipment would sit there uncommissioned, albeit maybe kept secure and we hope protected from the weather. So I think there's a number of factors there. I can hardly improve on Vincent's answer with respect to the 84 days, but if I may just throw in my own 2 cents on that. I would certainly agree, and of course I would caution the party that is looking to terminate, as I would always do in a potential termination scenario, notwithstanding that FIDIC affords you that route. I think nevertheless you have to take great care that you will not, well, a couple of things. One, that you are really entitled to exercise that right. I think you also need to give, and this in a way might be protective of the party that fears being terminated. I think you need to give extremely careful thought to your duty to mitigate your losses. So in circumstances where you purport to terminate, but the contractor has actually been engaging with you and suggesting workarounds, I think in circumstances where you have not elected to take those routes, you may be prejudicing your right to recover damages of another party's performance down the line. And I think sitting on top of all of this, and at the risk of putting it too bluntly, if you terminate me, who else is going to do it? Or if you terminate me, who in the world today can really honestly promise that they will remobilize or mobilize more quickly than I could remobilize, or give you better cost and time control and certainty than you already have? So I think Vincent, first and foremost, is quite correct in saying we're not there yet. But I think that's an avenue that parties need to be considering, particularly where there may be some commercial incentive for one party to get out of a deal that it no longer wants to be in.
Nelson, I think you're on mute.
Yeah. That's right. Thank you very much. The question is from the floor. It said, assuming that COVID-19 gave rise only to time entitlement, if there was another overlapping, just bear, no, sorry, just lost my text. Just bear with me for a minute. Okay, sorry. It says, assuming that the COVID-19 gave rise to only to time entitlement, if there was another overlapping factor giving rise to entitlement of both cost and time, which factor will be prevail? What will be the entitlement only time or both time and cost? Tricky question. Who fancy that? Is that Vincent?
Yeah, sorry, I was unmuting my mic. Yeah, I think we may not necessarily see that as a prevailing factor or things of that kind, but more as alternative or additional factors to be taken into account. And in fact, in our contract, we have specific remedies for force majeure events or exceptional events, but we have also parallel remedies in terms of government action, for instance. So any change in law, and again, I stress the fact that our definitions of law is pretty wide. So it covers not only legislation, but also governmental orders, regulations. It goes down to your municipality level. So if you have orders in parallel from your municipality and banning you to do any work within the perimeter of that municipality, even though you might be struggling on the other accounts to argue for a force majeure case, although as Charles rightly pointed out, this kind of municipal order would of course support your argument. But nevertheless, you can have this parallel entitlement, which is in fact a cost and time entitlement under our suite. And not only cost actually, because if I take the example of government orders right now, which are saying, okay, you have to get on with construction activities nevertheless, but provided you put health and safety measures into place, those additional health and safety measures like social distancing, like transportation of workers, we are currently seeing this. You should not have a full bus of workers going to the site, but you should have one worker per bench, for instance. This will cause disruption. And if I think of our clause 13.6 in the 2017 suite, as soon as we have a change in the law, so in the broader sense of it, which affects the execution of the works, then a variation is triggered. And a variation then would not only generate cost and time entitlements, but also a payment of profit. And again, if you are under the red book, then you would be looking at relying on the rate that you have in your bid of quantities. So you may well then take all this as a health and safety change of requirements, If you are under the yellow book or the silver books, that means somehow your employer's requirements are changing, not necessarily flowing from an instruction from the engineer, but because of the change in the law in relation to this COVID-19 situation.
Charles, can I put the same question to you under the US jurisdiction? I think we've talked about COVID is definitely or looking towards force majeure and whether one is entitled to time. If there are other prevailing issues which occurs at the same time that may entitle one to both cost and time, what's the interpretation in the States?
Nelson, in considering this question and also looking at some of the commentary that is presently circulated, it seems that in addition to looking at the specific contract provisions, it's also important to consider client behavior in responding to the agreement or in working with the design professional. If the client's own actions lead to unreasonable delay, even if there are not necessarily specific contractual provisions pertaining, there are certain common law principles that may come into play. Constructive acceleration, for example, which may provide grounds for recovery for the design professional's costs. It's important, I think, whether you're speaking of force majeure, change of law, or any other provision, to be mindful that none of these provisions operate in a vacuum. And you need to really look at every tool that you have available, both in law, in statutes, and in the common law of the jurisdiction in which you're operating. So it's important not to have tunnel vision. It's something that I would suggest in response to the question.
Since the question was put to the panelists, you'd be remiss of me not to give Angus and Clare opportunity to have a view on the same subject. Any view on it, Angus or Clare?
I'm not sure I have much to add to the previous speakers, Nelson, but I defer to you and Clare.
Awesome. Okay, Clare?
No, I don't either. Thanks, Nelson.
Okay, thank you very much. I'll go to the other question that comes through. This is actually specific to do with the Red Book, and I'm going to have to read it out, bearing in mind that I'm not a qualified lawyer. Apparently, the FIDIC Red Book, subclause 9.1 and clause 1 and 4, does not identify epidemic as an example event, noting that in the starting paragraph, the phrase, but is not limited to, is given. However, in subclause 8.4, the word epidemic is used. What is the reason for omitting the word epidemic in the subclause? Vincent, I think this is yours, really specific. Now, can I qualify before you respond? I don't expect you to have the contract with you and to be able to pontificate exactly on the issue. I think the issue is about epidemics. You would have mentioned it or not. Vincent?
Yeah. I think the answer is pretty straightforward in the sense that, yes, it's right. We specifically talk about epidemic in clause 6.7, where we say that the contractor should ensure all relevant measures to prevent epidemic. We also have subclause 8.4d in the 99 edition, which provides for a time entitlement in case you are getting delayed because of unforeseeable shortages caused by epidemic situation. The reason that it's not expressly covered in clause 19.1 is that, again, 19.1 list of events is not meant to be an exhaustive one. I think we took into consideration the fact that epidemic can well have a serious effect on the delivery of the job site on site. You have epidemic every year in many places, whether that's flu, whether you have Ebola, etc. So that's something which is a recurring matter. In the various countries where FIDIC contract operate, and in particular in connection with multilateral development bank financing, this is a recurring matter, hence the fact it's under clause 6.7 and 8.4. Because even though you may not have a force majeure event, for example, because you may have a very localized issue of epidemic in one area of your country, you may nevertheless, and then you may have a difficulty to justify it's a force majeure case, you may nevertheless suffer from supply chain issues, hence subclause 840. So that's basically the reason why it's not specified as expressly in 19.1 of the 1999 suite than in other clauses. And again, because we are dealing also with exceptional events. So by definition, we cannot foresee in advance all exceptional events which might come into play.
Okay. Thank you very much, Vincent. Another question from the floor from Doris Martha. And she said, if the employer instructions suspension of work without citing force majeure, but directing to government order, can the contractor claim relief under the suspension by the employer, still seeking excuse from performance?
Do you want me to answer that one?
I thought, Angus, you want to have a go on that?
Yes. Well, I may need to be corrected by Vincent, certainly, because I didn't have the contract open.
Well, actually,
sorry.
This is not targeted towards FIDIC contract. It was a generic question.
Indeed.
Let me repeat. It says, if the employer's instruction, suspension of work without citing force majeure, but directing to government order, can the contractor claim relief under the suspension by the employer, still seeking excuse from performance?
Well, I know this answer always comes up, but assuming we may not be working with a FIDIC form, it will be essential to look at the suspension clause. But I would have thought, looking at this in the contractor-friendly way, that in circumstances where the employer has unequivocally told you to stop and given you that instruction, well, you potentially have an entitlement to EOT, but also you may have an entitlement to costs which you wouldn't otherwise have arising from that. But that's a really quite general statement that would need to be heavily qualified by contract terms and governing law.
Okay, thanks very much. There is a question here from Nepal, and I think, of course, FIDIC is global, and this may be interesting. We probably have the answer already. It said our country, Nepal, is locked down 17 days. Can we consider COVID-19 as force majeure or not? Presumably, the question is being asked from their jurisdiction point of view. Can they consider COVID-19 as force majeure?
May I try to take that one, Nelson,
yes,
initially,
please.
if I may, and then I should shut up. But I think that question really pulls together a lot of the themes we've been discussing so far, which is that, as Vincent said, I think COVID-19 is capable of being a force majeure event under the applicable law if it provides for it. But for the purposes of today's call, COVID-19 may be capable of being an exceptional event under the contract. Now, of course, it will still need to satisfy the general criteria with respect to being something that the affected party couldn't reasonably have avoided or overcome. So I think the danger is getting so hung up on the definition of the trigger event, you think that once I fall within that definition, I'm home free. You will still need to be able to satisfy, of course, those other criteria, and you are still subject to duties to mitigate. So obligations which are not impacted, you still have to perform them, and obligations which have been impacted, you are under a duty to mitigate generally. And I think furthermore, the key word I keep raising is causation. In order for you to establish your entitlement to relief, you will have to show a causal link between either the virus and or the changes in law arising from the virus. You have to show the causal link between those things and the impact on your performance.
Nelson, can I just add, I think it's really important that people don't view force majeure as some kind of get out of jail free card. I think the points Angus is emphasizing there are really important. So, really step back and look at the whole picture and all of the measures, all of the steps that need to be taken under the contract.
Very, very, very valid point, Claire. The other question has come through from, and this is directed to all panelists, and this is to do with the source of COVID-19. So the supply chain has been disrupted from the time China had ceased to operate. And the individual country have been impacted at different time with the supply chain. What is the overall implication? Could we talk more about the ramification of that if the supply chain, is being disrupted, and as a result of that, work cannot continue under the FIDIC contract? Who fancy taking that on? Vincent?
Yeah, but just take a concrete example. Out of the recommendations we have in various countries right now for construction activities to resume, you are encouraged to have social distancing. That's fine, but sometimes it's not possible. And if the social distancing of 1 or 2 meters, depending on countries, and some countries say it should be 1 meter, some others say it should be 1.5, some others say it should be 2 meters. So I don't know whether there is any specificity of the virus depending on countries, but anyhow, we have those different regulations and all recommendations which are put in place. But in some countries, it can be very difficult currently to find masks. A face mask. So that could be a clear shortage of supply for you guys whenever you are to implement those recommendations or regulations from your government. So again, that's something you can rely upon in your contract in order to get a time relief, and again under subclause 8.4d or subclause 8.5d in the 2017 suite. But definitely, yeah, you might well be in a country where currently there is no strong COVID crisis, where there is no governmental ban or whatsoever form. So you would have a hard time to justify force majeure. You would have a hard time to justify governmental order or change in law following our contract terms. But you may well find another remedy under subclause 8.4 or 8.5 in 2017 edition.
Do you have a view on that, Angus?
Nothing further to add at the moment, Nelson. Thank you.
There's a question directly for Clare here. I think, Clare, you cited in your conversation about the need for us to move into digital world, and sometime when you look through, now we're having this conference call or this is the webinar, what you can achieve with technology. I think you cited the use of, if I've got it right, is a sort of this is to use with the video or means of, I think the question is really phrased along the line that, do you think that conducting a site review by video or other means will meet the standard of care required for an engineer? I suspect with the technology, the answer will be yes. What's your take, Clare, on this?
Yeah, obviously it's a very general observation and you'd need to look at the specifics. I know that we've had conversations about, for example, using drones to go around buildings, and it's impossible to get the kind of footage that you need to be able to get into the intricacies of, say, an M&E design and checking that. So I absolutely agree, that's a really important point. But where it is possible to very clearly see, there might be specific criteria we're looking to have been met, and certification of products and things like that that can be achieved through video footage, or doing a survey, technology-wise through technology of a big structure or something like that. Those are tools we're already embracing and delivering our services. But yes, it's a really important point.
Thank you very much. Now, I'm actually going to put a series of questions. This is wrap up. There's a lot of questions coming through from the floor, and I did invited Aisha, if she's boasting that she wants to contribute. You're welcome at any point to put any question. But just try and look at so far, FIDIC has gone through and produced a guidance note, which is really, we've been trying to communicate with our member and the industry. And I think I hear loud and clear from Clare's comment, talk about collaboration, positive. You're looking at collaborative insurance. I heard the word earlier on in the issue about, this is quite unusual. We've never gone through this experience before. And I also hear the issue and concern about people on the front line. I just wonder, as an organization that represents over 102 countries around the world, 40,000, professional consulting firm, employing and representing about 6.5 billion. What else would you advise us that we could do in addition to what we are doing? Can I caution you? Sometimes you have to be careful what you wish for. I'm looking for advice here. What else can we do to try and help? Because I think I hear a lot of very positive message that, yes, if you stop the company or stop the job, who is going to pick it up? as an organization that promote best practice, as an organization that has tried and tested system and procedure. And I like to nick Angus' word that, yes, you have a mean machine that is being tested. What else can we be doing as an organization to try and help the world in the direction we are? Because we need to end up with an industry that is sustainable. We need to have an industry that we can attract more people to come to. We need to have an industry that is not seen to be litigious, but yet we need to find a solution out of this. So I'm going to start off with Charles. What would be your advice, to us? Charles, you have to unmute.
I apologize, Nelson. No, it is such a large question that is being asked. The raison d'etre for an engineer is to help society, to solve problems. This is the largest problem the current generation of humanity has ever faced. So in terms of how how engineers as a profession and as an industry can respond to this current crisis, it involves, I think, virtually every skill set that the profession commands. I apologize for speaking in such broad generalities, but it is such an awesome question that is being posed. All I can say is that the minds and the talents of the entire American engineering community are bent on this question. As to how the FIDIC constituent members, the associations representing the interests of the world engineering community can respond. I think my instinct is to say in two fundamental ways, which FIDIC and ACEC for its part have also been trying to do. First, we have to educate ourselves. This entire crisis has been a crash course on epidemiology, on world demographics, on basically the ability to separate truth from falsehoods in the information that is being circulated. And now that the associations, I believe, certainly are very well informed on the challenges presented, then we have an educational mission. Basically, what ACEC is doing is every day, almost around the clock, we are circulating the latest information to our member firms on virtually every aspect of this problem. Solutions from government, solutions from the CDC, from healthcare professionals, solutions from the legal community, a great many solutions from the legal community. Angus, correct me if I'm wrong, but my sense is that so many firms are offering daily, if not hourly, information, webinars, programs, etc., on how engineering firms, design professional firms should respond to this crisis. So I would offer that for you. And I apologize for rambling. It is such a large question.
Well, we're coming towards the end now, Charles. I appreciate that. Clare, looking at you as a global leader in a global firm with global footprint, understanding that in each country that you operate from, there is an association, be it Australia, be it America, be it UK, and everywhere that Arup is. What do you expect of those associations, and how can they support you to make sure all the points you raised earlier on about people, technology, collaboration, and activities, so how can we get that across to support you as an organization? If it's good for Arup, it must be good for the rest of the world. What will be your one sentence advice to FIDIC?
I think kind of as anticipating what's coming and to support that, and as you say, Nelson, resilience is critical to this, and sustained resilience. So really trying to stay ahead of the curve and providing support actually to some of the SMEs and the smaller businesses that you represent around the world who don't have the infrastructure and the support services that the firm the size of Arup does have. And I think that's where the membership organisations can really make a difference for their members by providing that guidance and support through these very challenging times. I was also going to just add around insurance. I think we do need to anticipate a tightening of insurance cover in all respects in relation to this type of risk, and I'm sure it will trigger other considerations. So perhaps looking at the terms and conditions of FIDIC contracts and anticipating what might come in that respect and getting those ready to be updated and amended accordingly.
Thank you very much, Claire. Angus, of course, we are talking about, legal. I hear your 3 points, and I just wonder whether you want any sentence just to close out from your side, Angus.
In terms of what more FIDIC could be doing, Nelson?
Absolutely, yes.
Okay.
Well, I mean, in terms of what FIDIC could be doing, but actually for the whole industry, because to some extent, it's easy for us to talk about the engineering and the construction and infrastructure industry. I have a slightly different definition for our industry, that all those stakeholders who are players in the market, including the legal, are part of our industry. So what can we do together as an industry to make sure at least not only do we get over this challenge, but we are fit for the future?
Yes, and nothing underlines your message, Nelson, more than this crisis. I mean, if it took this to underline that we are ultimately all in one boat, it may not always seem that way. I think we're certainly understanding that now. I suppose my final thought would be, please keep continuing FIDIC with all the great support you're doing, particularly in the way that you edit content and present what might be most helpful to your members. But I'd also like to see you being a thought leader on lessons learned. I think it will be very interesting to come back later and look at this webinar in months ahead and say, well, Clare, Angus and others were talking about being contractual, but being collaborative. What worked and what didn't? And I think if you could find out what factors made the difference in the parties getting a deal and what factors in the end stopped the parties from getting a deal and sent them down the road of your DRP, I think that will be very interesting for you to aggregate that.
Thank you very much, Angus. Vincent, you started it, but I'm going to let you close out from the panel, and then I will invite Aisha to say thank you on behalf. So, Vincent, what's your closing remark?
Yeah, thank you, Nelson. My closing remark would be twofold. First, I've been especially talking about the FIDIC contract terms, but as it has been already emphasized, that's not the only way to look at the situation. You have to take into account your matrix of facts, which is surrounding each case before coming to definitive answers. You have also to look at the terms of the law, your applicable law, and beyond all this, you have also to look at the way this situation is currently seen, socially speaking, in terms of corporate entities and your corporate social responsibilities. You may be ill-advised to take hardline adversarial approaches those days. We have several governments who are already about or are issuing recommendations which might become orders in the future to stay a little bit away from a brutal application of contract terms. So that's something to bear in mind. And the second part also of my message is about our specific features in FIDIC forms of contract. We have dispute boards. We have dispute avoidance and adjudication boards in the 2017 editions. We have dispute adjudication boards in the 99 suite. We have adjudicators in the White Book or in the Green Book. Think of going to those people. You can ask them for opinions in the current situation where we are in. You don't have to wait for a dispute to crystallize before turning to those guys. They are there to help you out. So I would recommend you not to hesitate to turn to your dispute boards or adjudicators so as to seek opinions and advices from them that may help you to stay away from entrenched and dispute-prone positions.
Thank you very much, Vincent. I'm going to invite Aisha. You led us, and I want you to say a few words before I wrap up. Aisha, the floor is yours.
Thank you very much, Nelson. Thank you to all our esteemed speakers. We've gone around the world discussing this, the risk, the COVID-19 risk, and how you might be able to handle it at a firm level, at a project level, and details within the contracts. I borrow Clare's terms about collaboration, complexity, and communication. And then I go to Angus, where he talks about understanding your contract well, but making sure that you build on those relationships and focus on collaboration. And go to Charles in the US and talk about the different interpretations of force majeure, understanding the applicable law in the jurisdiction that you are operating in. And then I ultimately land on Vincent's comments and reminding about the collaboration and dispute avoidance and the tools that are available in FIDIC contracts. And if you're not using a FIDIC contract, I'd invite parties to focus on collaboration and maybe looking for engaging a neutral. This is a time of high emotion where you might look to a third-party neutral to facilitate your dialogue such that you can focus on collaboration and achieve a product where you can take advantage of windows and not lose windows of opportunities, as Angus talked about, weather windows and the like. So I just want to say, and thank you, Nelson, and your team for putting together an excellent webinar in such a critical time.
Thank you very much, Aisha, for that closing remark. We plan to finish at about 1:30, and we're about 3 minutes over, but I can still report to you, we still have over 600 people online listening to this particular topic. I did start it off by saying we have embarked on a journey where we have 10 agenda, but that 10 becomes 20. We intend to roll it out over the next 10 weeks. And we're trying to put that across. A lot of the points being talked about earlier on about insurance, people, relationship, dispute resolution, and all sorts of things, including lesson learned, as raised, by Angus. All those will be covered over the next few weeks. And I just want to challenge everybody who is online to signpost this particular, webinar to their friends and colleagues who may be interested. But just really to try and wrap up, I'll probably say, massive thank you to my panelists, from Vincent to Clare, to Angus, and to Charles, for taking the time, particularly Charles, who I have to wake you up very early in the morning to support us on this, and your input is highly appreciated. But also massive thank you to Aisha, who oversees our activity within FIDIC, and also to Bill, our president, who I had to wake up early this morning as well to support us. But more important also to my staff who within FIDIC, all working from home, with the exception of Barbara, who have to go to the office during this difficult time. Hopefully, we are all protected. But I want to thank every single individual participant. We had close to 800 people at the peak period, and we are still on 600 people on the list. So it must be a good conversation. The next one is going to be on the 14th of April, which is next week, Tuesday. We'll be looking about the major project involved parties in joint venture. Again, we've assembled a lot of global leaders. Our plan is to truly represent the globe in terms of people who speak. Today, we've experienced somebody from North America. We have Clare with a global remit looking through. We have Vincent overlooking, and Angus, whose company's footprint is all over the world. So I'm really pleased that we're able to put this together. The next one, impact on joint venture transaction. This should interest a lot of people. Once again, I want to thank everybody, my staff, the panelists, Aisha, and Bill, the president. Thank you very much. I hope you've enjoyed the webinar, and I wish you safe part. God bless. Thank you very much. That's the end of the webinar. Thank you. Bye.
Thank you. Bye-bye.
Thanks, Nelson.
Thank you.
Thank you very much.
Thank you and goodbye.
Very much. Thank you.